The Major Questions Doctrine is an idea that, jurists disagree about exactly how it's supposed to be understood, this doctrine, and how it functions when judges decide cases. But the basic idea is that if you're dealing with an issue of tremendous social, political, or economic significance, then the court has to pay very close attention to the law to make sure an agency has the ability to regulate. So one of the most recent cases dealing with major questions was the West Virginia versus EPA, which had to deal with carbon emissions and the EPA's ability to regulate that on a widespread scale. And the court said, look, EPA, you don't have the authority here because Congress hasn't spoken very clearly.
Americans are capable of achieving extraordinary things when they have the freedom and opportunity to do so. This is American Potential.
Welcome to the American Potential Podcast. I'm your host, David Frum. Since taking office, President Trump has been signing executive orders covering issues from border security to healthcare. And today there's one we are going to discuss called the Ensuring Lawful Governance and Implementing. So, what does this executive order focus on? Its goal is to put the unaccountable administrative state in check. For years, these unelected bureaucrats have been operating unchecked, stretching vague laws to push regulations that Congress never actually approved. But with this executive order, Trump is trying to rein in some of these out-of-control rules and regulations that have real-world impacts on Americans and businesses. This order leans heavily on three key Supreme Court doctrines, two of which we've talked about previously on this podcast. I want to welcome Ryan Mulvey, who is Policy Counsel for Americans for Prosperity Foundation, back to the podcast to talk about this executive order and how these Supreme Court decisions are playing a role. Ryan, welcome back.
Hi, thanks for having me. It's great to be here, David.
Great. Well, we spent a lot of time over the last number of months talking about what you've been working on for years, really. And it really is an exciting time in terms of trying to rein in government. And you've really been kind of part of the tip of the spear. So with this, in this executive order in particular, what have agencies been told to do?
Sure. So I even want to step back just a step and talk about how this kind of fits into the broader DOGE agenda, because I think it really is an important part, and the importance of this executive order in particular really needs to be underscored. I think most of your listeners will know generally what DOGE is and what it's set out to do. And I think a lot of the publicity to date and a lot of what DOGE itself has been making available is information about its efforts to modernize and make more efficient aspects of the government, particularly its payment systems. And it's been going out. There was another executive order on cost efficiency. And that has directed the DOGE teams at agencies to look at reviewing not only the payment systems, but contracts and grants and how agencies are spending money generally, and what property holdings do they have, and how do we make agencies leaner machines, right? And saving the taxpayers' money. This executive order, as you point out, I think personally is way more exciting, and in the long run will even be more impactful, because regulation, the regulatory apparatus of the federal government, is really the way that most Americans' lives are impacted by the federal government. If Congress passes laws, and Congress needs to do a better job at passing laws, but it is regulations that govern most aspects of our day-to-day life. And what this executive order does, in large part, is direct agencies to take a really hard look at the regulations that are on the books and to put together lists to submit to OMB's Office of Information and Regulatory Affairs, OIRA is what it's called, to put together these lists of regulations that need to be, drawn back, regulations that need to be cut. And the EO identifies 7 categories of EOs that should be included in that list. And the 3 that I think are the most interesting implicate those Supreme Court cases and doctrines that you mentioned. So specifically, if an agency feels that a regulation is based on an unlawful delegation of authority from Congress to the agency, or if an interpretation doesn't represent the best interpretation of the law, that hints at Loper-Bright and the end of Chevron deference. So all those regulations that were based on reasonableness and step 2 of the old Chevron regime, those are on the list too. And then the last is where there hasn't been a clear statement of authority given to the agency to regulate on matters of significant social, political, or economic significance. So if you have a regulation that's attempting to govern, all of artificial intelligence, for example, where the agency has really just gone beyond what Congress ever very clearly gave it the authority to do. Those regulations need to be identified, and then plans need to be put in place to get them off the books. And I would add, there's another a very interesting element of this EO too, which has to deal with the exercise of enforcement discretion by the executive branch. So, regardless of what regulations are on the books, agencies and their heads enjoy a certain amount of discretion to choose whether to prosecute those regulations against people. And some agencies have been really creative, I think is one word you could use, about when they choose to enforce against regulated parties and how they choose to enforce. And this EO, again, with the put on your Doge hat, they're looking at how do you save the taxpayer money. We shouldn't have adventuresome enforcement proceedings where agencies are kind of getting ahead of the law and being creative in a way perhaps to aggrandize their own power. Those sorts of enforcement proceedings need to stop. And this EO aims to achieve that goal.
Well, so I think last month we talked a little bit about the case involving the non-delegation doctrine. We talked to Casey Maddox about it. But for those that missed this episode, what is the non-delegation doctrine?
So the Constitution, the founders were really wise, right? And they set up our system really well. And the idea behind delegation, we actually step back to Article 1 of the Constitution, which vests or gives Congress all the legislative authority. Delegation is the decision at a very general level, the decision of Congress to give an agency some duty to assist it in its legislative, in the exercise of its legislative powers. The issue with non-delegation is that there are certain things or certain instances in which it is entirely inappropriate, even unconstitutional, for Congress to attempt to give its legislative authority over to an executive branch agency. It's a violation of the separation of powers. And, for a long time, it's been very difficult to get the Supreme Court to really enforce this part of the Constitution. I think a lot of us are very hopeful now that that's the atmosphere on the court and its desire to, really revisit these foundational principles of the design of our constitutional system. It's primed to maybe revisit this issue a little bit. The case I think you discussed, involving the FCC, has to deal with whether or not that agency, with one of its funding schemes, is able to bypass Congress's sole vested authority and non-delegable authority to levy taxes. Only Congress should be able to tax. That taxing power is non-delegable. So getting courts to start policing Congress's delegations will be a really important step in getting the administrative state back under control.
So you said that it seems like the Supreme Court has been moving more and more in this direction of addressing regulatory overreach, or whatever this is involved in this bucket. What dynamics on the court do you think are making that happen? Is it the addition of is it different justices, or some just waking up more in a certain area? What would you attribute that to?
Well, I certainly think the composition of the court influences that. What it's willing to do. But I also think there's been just a lot of development in the academy, legal scholarship, and in the arguments that are being brought before courts. And there's also just a natural progression in the doctrine. And I think for a long time, even as Justice Kagan would say, we're all originalists now, and we're all textualists now, and even liberal-leaning judges have to take text more seriously. And when you start to take the text of the Constitution more seriously and understand the whole framework and how it's supposed to work, you begin to see how some of the more progressive doctrines that developed in the United States over the past 100+ years were wrong. I mean, the best example of that, I think, and where my personal experience is with the Chevron Doctrine. Was only from 1984, but this whole idea of implicit delegations and how ambiguous laws, agencies in the executive branch should be given basically a thumb on the scale on their side, as it were, simply because they're the government. I mean, that's the wrong approach to statutory interpretation. It's the wrong approach to understanding how Congress gives power to agencies, and it's the wrong understanding of how you should be understanding agency power from the get-go. So I think there's a lot of dynamics that have helped make these challenges, to non-delegation viable. And fingers crossed, we'll get a good outcome for those who care about liberty.
Yeah. So you mentioned Chevron deference and the Loper-Bright decision, which basically did away with that, if my understanding is correct. For our listeners, we've talked about a number of times on this show, but in fact, I believe you were on with two of the fishermen who were involved in the case, which is pretty exciting.
Yes.
Chevron deference was basically the court was saying that agencies are favored. Is that kind of a simplistic way of put it?
That's a very simple. Yeah. I mean, the general idea was that courts were, so the view that now prevails, and the one that I think the founders had in mind when they designed our system, is that judges are supposed to be the ones responsible for interpreting the law. What Loper-Bright, or rather what Chevron did, was it said when you're dealing with agencies, so when you're dealing with administrative law, regulations, and all of that, notwithstanding, judge, what you may think the best meaning of the law is, what you as an independent arbiter, as a federal judge, what you might think the law means, if there's any argument that there's ambiguity, or if there's a silence in the law where an agency is trying to say that silence gave it some sort of authority implicitly, right? If the agency says that, and it's arguable that ambiguity exists, you stop and you don't construe the law. You don't give it its best meaning. Rather, you ask whether the agency's position was reasonable. And you can see how that, I mean, most people, when they hear that, it just seems wrong. Think of the normal instance of litigation. Two regular people litigate against each other, and there's a term of their contract that's ambiguous, or maybe there is a law that's relevant to the lawsuit, and it's unclear what the law means. What is the job of the judge? The job of the judge is to give meaning to the law, to find out what the law actually means, and then to resolve the case. That shouldn't ever change just because one of the parties is now the government. And yet that's what Chevron did for 40 years. So that's gone now. And, the court has said that the Administrative Procedure Act, the judicial review provision in that law, requires that judges give their independent judgment as to the best meaning of the law. And that's a great outcome.
Yeah, that is. Yay for freedom and an authentic reading of the Constitution. How did the Loper-Bright decision play a role in this executive order?
So, one of the types of regulations that are supposed to be identified under the EO are rules that are not based on the best reading of the underlying statute. So again, Loper-Bright comes in, the Supreme Court says Chevron deference is gone. the job of the judge when there's a question of the meaning of law. The judge is tasked with figuring that meaning out. So now, one thing that the Supreme Court said, though, in reaching that decision, it said, we've had 40 years of Chevron cases, and we're not disrupting those cases. This is kind of like the new standard moving forward. There might be challenges to those older regulations that were decided under Chevron, but they're going to be given what's called statutory stare decisis effect, which means it's going to be really hard for people to try to, at least in theory, to have courts revisit those cases. Now, you can argue or quibble with the chief about exactly how that's going to work out in the courts and how stare decisis is going to play out in the circuits. We've had, if folks check out AFP Foundation's Recasting Regulations blog, we've been posting great updates post Loper Bright about how the decision is being implemented. And I just had a piece talking about stare decisis, and we've had a couple other posts up there. But regardless of how the courts figure things out, agencies can still take action. And we have an executive branch that is now staffed by folks who think Loper Bright was a great decision and the end of Chevron was a great development. And what they can do now is help move things along by looking at those older regulations that it might be really hard to overturn in court, or where there might not even be, realistically speaking, a plaintiff who can challenge for whatever reason, whether there's a statute of limitations that's run or other standing issues. Now, the executive branch, the agency, the regulator itself can go back and say, did we get this right? Like, do we really think that our regulation implements the law as faithfully as it can? Is it the best reading of the law? And I mean, that's the ideal, right? Is that regulators start to revisit their own regulations. And that's exactly what this EO does.
That is exciting. So my understanding is that the next case involves the Major Questions Doctrine. What is that? And what is its role?
So the Major Questions Doctrine is an idea that, jurists disagree about exactly how it's supposed to be understood, this doctrine, and how it functions when judges decide cases. But the basic idea is that if you're dealing with an issue of tremendous social, political, or economic significance, then the court has to pay very close attention to the law to make sure an agency has the ability to regulate. So one of the most recent cases dealing with major questions, was the West Virginia versus EPA, which had to deal with, carbon emissions and the EPA's ability to regulate, that on a widespread scale. And the court said, look, EPA, you don't have the authority here because Congress hasn't spoken very clearly and given you this power. And, if you were right in your view of what you could regulate, you'd be able to regulate anything. You'd basically be doing what Congress should be doing. So I think that's the best way to think now of Major Questions Doctrine is as what we call in the law world a clear statement rule. When the issue at hand is something that's tremendously impactful on the country, did Congress clearly give the agency the authority to regulate? And if it didn't, then that power isn't there. So this EO tackles, that doctrine and brings it into the regulatory reform process by saying, hey, look, even if you think that this, regulation is useful and good policy, is it dealing with an issue that really belongs to Congress? Or more precisely, if we think it otherwise would be something normally handled by Congress, has Congress very clearly and constitutionally, because let's think about non-delegation too, all of these doctrines, they mix together. And I can touch on that in a second. If the delegation is constitutional, did Congress still very clearly give us the authority to regulate? And if it didn't, then that regulation should be gone.
So you touched on how they all mix together. Yeah, please extrapolate, because I think that is probably one of the cool parts about this executive order.
Yeah, so one of the really interesting parts of Loper-Bright is, as I mentioned, the Supreme Court said, look, questions of law, fights over legal meaning, are to be resolved by the courts. But the Chief Justice, in writing the opinion, said, there can be some instances where Congress uses language that by its nature gives agencies a little bit of discretion to regulate, a little bit of policy-making discretion. So an example of this would be if Congress tells an agency to set reasonable standards, or if it gives it the authority to do whatever it deems necessary and proper, or necessary and appropriate to affect its other clear regulatory authority. The court said in Loper-Bright, when you're dealing with that type of situation, the job of the judge, it's not to defer, but it's a four-step process, as I argued on remand in Loper-Bright, that this section of the opinion sets a four-step process for judges. Their first job is to identify that there is a delegation here with the use of that broad language. 2, to determine whether or not that delegation is constitutional. And there we get to the non-delegation doctrine that we touched on earlier. The third is to find the limits of the delegation. So with a term like reasonable, in context, what does reasonable mean? Or what are the bounds of what the agency can do? And then the fourth is to determine whether or not the agency acted within those bounds. Did it act reasonably? Or is its determination about reasonableness correct? So those are your four steps, but you can see how there are elements of non-delegation in that. There's an interplay between major questions and non-delegation and Loper-Bright. All these things come together, and that's why they're all mentioned in this EO, because all of these touch on reining back in the regulatory state and getting it back under control. And that's even clearer when you look at, I mentioned at the beginning that there are 7 categories of regulations. We've touched on the big 3, but there are other ones. One of them is, does the regulation put undue burden on small business? And does it impede a private enterprise and entrepreneurship? Because if it does, we don't want, as a policy matter, the president doesn't want that sort of regulation on the books. So again, exciting times to see these sorts of things really being grappled with by agencies that haven't had to do, I don't think they've ever had to do anything really like this.
Would you consider this moment in time, from a policy and legal standpoint, one of the most exciting and potentially transformative? Maybe characterize it for us in recent history.
Yeah, I think that there are, how things resolve out, we'll see. I'm not on the Supreme Court, so I can't read their minds, but there are a lot of issues now coming to the front that will need to be decided by the court, and a lot of them are issues that will have a huge impact on ordinary Americans' lives. Loper-Bright, which coincidentally enough wasn't even, it wasn't. We never expected that case to be about overturning Chevron, and yet it is, and it really does illustrate how Chevron impacted regular Americans and small businesses so very much. That win now was only the first step. Getting rid of Chevron deference by itself is a great thing, but it's not the end of the administrative state. It opens the door to a whole bunch of other issues that now need to be resolved, and not just resolved by the courts, but that need to be resolved by the rest of the federal government, by Congress. I like to call Loper Bright an invitation to Congress to reassert its Article 1 authority and to take back the power of writing law. And I think there's a lot of interest in Congress in doing that. So that's a great development. And then there's the executive branch responding exactly this way, which is getting itself back under control and getting regulators back under control. But from all these admin law issues to, the authority of the president to manage the executive branch, through his management of officers, independent agencies that claim to be free from, the president and Congress, all these issues are primed and coming, and it is an exciting time for people who care about limited government, who care about the Constitution. I'm certainly excited.
Yeah. Well, I've been, as we've talked to experts like yourself about what's been happening in a lot of these cases and how things are adjusting with regard to the branches of government, it just occurs to me, I've been kind of calling it like, hey, stay in your lane and actually do your job. It's kind of the time that we're in right now. It's like, we want Congress to do their job and live into what the founders saw them doing. And we want agencies to to stay limited to what they're actually authorized to do and kind of right size government back to the way it should be.
That's right.
Just a final question. What does Congress need to do to make these changes permanent, and how can the new DOJ subcommittee and caucus play a role in that?
Yeah. So one thing one of my colleagues has written about, James Valvo. If you visit our Recasting Regulations blog on the AFP Foundation website, you can read about this. One of the things that really needs to be done to wrap everything up, and make it long lasting, to make it durable and really effective reform, is for Congress to jump in on the game. It's really not enough. It's not ideal for everything to be done by executive order, right? What really should, in an ideal world, the executive should present proposals to Congress, and then Congress, affect those reforms proposals into law. Now, the EO, there's a lot that can be done, and this EO is great because it does exactly the sort of thing that is legitimately within the executive branch to do, and it's long overdue. And a lot good is going to come from exactly what it outlines. But for more lasting reform of the administrative state, statutes need to change, and that can only happen with Congress. So Congress getting involved with that, there's already a lot of great legislation that's out there, and that's I'm sure is going to be reproposed, reintroduced in this first session of the new Congress. That like Reins Act, the Good Act that deals with transparency, the Republic Act, I think it's called, which deals with reform of emergency powers. There's a lot of stuff that a lot of great legislators are interested in doing to fix, to just fix the problem with holding agencies accountable, getting Congress involved in approving more significant regulations, conducting or facilitating oversight of what regulatory agencies are doing. And then just apart from admin state reform, Congress, I know because I speak to members and their staffs, we have a lot of legislators that are interested in being legislators, right? And in writing laws, taking federalism seriously, taking Article 1 and the scope of delegated authority, delegated powers given to the federal government. They're super excited to work on all of that. And gosh, if we got an executive branch and a Congress working hand in hand with a Supreme Court, all to bring everything back in line with the Constitution, I mean, that would make America great again.
Yeah, that would be fabulous. Yeah, trying to live into the vision that the founders had when they wrote our founding documents would be pretty amazing. Well, Ryan, thank you so much for coming on again to walk us through, in this case, this executive order. We really hope that, we can keep having you back and talk about the progress in right-sizing government, really embracing limited government and getting back to, what the founders laid out for us.
Yeah, it's been a pleasure. Thanks so much. Anytime, I'd love to come back and talk with you, David.
Cool. Thanks. Well, hey, folks, if you like this episode and would like to stay connected with the podcast, be sure to like and subscribe to our channel, as well as following us on Facebook, Instagram, and YouTube. Always remember, liberty and freedom are easily taken for granted. Don't take it for granted. Go out there and defend liberty and freedom. Thanks for joining us, and we'll see you on the next episode.
Thank you for listening to American Potential. You may listen to more stories from Americans working every day to expand freedom and opportunity in their communities by visiting AmericanPotential.com.